My ex-husband filed a lawsuit demanding half of my $14 million inheritance. He laughed loudly, but I just smiled and called my lawyer when my lawyer pulled out one document at the court hearing. My ex-husband went silent. Good day, dear listeners. It's Diana again. I'm glad you're here with me. Please subscribe to my channel and like this video. And also let me know in the comments which city you're listening from. That way I can see how far my story has traveled. People always say you know when a marriage is ending. They say there's a moment, a single crystalline instant, when you look across the dinner table and understand that the person sitting opposite you has become a stranger. I used to think that was poetic nonsense. I used to think love was sturdier than that. I was wrong about a great many things. My name is Sarah Mitchell. Or rather, it was Sarah Mitchell for 11 years. Before that and after that, I was Sarah Hartwell. And I have learned, in ways I never anticipated, that the name you're born with carries more weight than the one you acquire through a wedding ring. Derek and I met in the summer of 2009 at a conference in Chicago. He was charming in the way that certain men are charming, effortlessly, almost mechanically, as if he had practiced the smile in a mirror until it looked spontaneous. I was 32 years old, building my career in healthcare administration, and I will admit it plainly, lonely. He was tall, funny, and he listened, or at least he performed the act of listening with convincing precision. We married in 2011 in a small ceremony in Asheville, North Carolina. My mother, Eleanor Hartwell, stood in the front row in a lavender dress she'd bought 2 sizes too large because her hands shook too badly to alter it herself. She was already sick by then, though none of us said the word out loud. She squeezed my hand before I walked down the aisle and said, very quietly, "Sarah, the most important thing a woman can own is her own judgment." I kissed her cheek and didn't think much of it. I thought of it constantly, 11 years later. The first warning sign came in the spring of 2019. I had noticed over the preceding months that Derek had grown secretive with his phone, tilting the screen away, stepping outside to take calls that he described afterward with the vague adjective, work. I told myself I was imagining it. I was 42 years old, and I had learned over a decade of marriage that Derek occasionally retreated into himself under professional stress. His architecture firm had lost 2 major contracts that year. It was reasonable to assume the phone calls were about money. They were about money, as it turned out, just not in the way I'd assumed. By the fall of 2020, I had found the receipts, not dramatic evidence. No lipstick on a collar, no perfume on a shirt. Instead, a hotel in Savannah for 3 nights in February that I had not attended. A restaurant charge in Atlanta on a Tuesday when Derek claimed to have been at a client meeting in our own city of Charlotte. Small fractures, but fractures nonetheless. Her name was Vanessa Cole. She was 31, worked in real estate, and had been seeing my husband for approximately 2 years by the time I learned she existed. I found out not through confrontation or confession, but through the particular cruelty of an accidentally forwarded email. A thread Derek had meant to send to her and sent to me instead, a Sunday morning mistake that changed the entire architecture of my life. I did not cry immediately. I sat at our kitchen table in Charlotte with my coffee going cold, and I read the email 3 times, with the careful, detached attention of someone reading a legal document in a language they are only beginning to understand. And then I called a divorce attorney. The divorce was filed in March of 2021. My mother died in September of that same year. She'd spent the last years of her life quietly, without dramatics, the way she did everything, finalizing the estate planning she had begun years before her diagnosis. What she left me was not unexpected in a general sense. My mother had been careful with money her entire life. A retired professor who had invested modestly, consistently, and wisely for 40 years. What I had not fully understood until her attorney contacted me 3 weeks after her funeral was the precise structure of what she had built. $14 million. Held in an irrevocable trust that she had established in 1998, 13 years before I ever met Derek Mitchell. I remember sitting in the attorney's office in Raleigh and hearing the number and feeling beneath the grief something that I can only describe as the sensation of solid ground. Derek heard the number 6 weeks later. By then, our divorce was well underway. By then, he had moved in with Vanessa Cole. By then, I had assumed the worst of the legal ugliness was behind us. I was wrong again, but this time, only briefly. His attorney filed the amended motion on a Thursday. Derek was claiming that the $14 million received during the calendar year of our legal marriage constituted marital property subject to equitable distribution. He wanted $7 million. I know exactly where I was when I got the call. I was standing in the parking lot of a Whole Foods in Charlotte, holding a bag of groceries, and the afternoon sun was very bright. My attorney, Patricia Owens, read me the motion over the phone in her measured, unshakable voice. I did not cry, I did not shout. I said, "Patricia, pull the trust documents, all of them, the originals." And she said very quietly, "Already done." The first time I saw Derek in the courthouse hallway, 3 weeks before the hearing, he laughed. It was a genuine laugh, relaxed, confident, the laugh of a man who believed he had already won. He was standing with his attorney, and Vanessa was beside him in a cream blazer, and he looked at me across that marble corridor, and he actually laughed. I smiled. Then I took out my phone and I called Patricia Owens. I drove home from the courthouse with both hands on the wheel and the radio off. That is how I know when something has genuinely shaken me. I stopped needing noise. The Charlotte streets were ordinary. Traffic lights, school zones, a construction crew on Providence Road pouring concrete for something new. The world continued its business as if Derek Mitchell had not just laughed at me in a public corridor, as if 11 years of my life had not come down to a legal motion and a man in an expensive suit. My house, which I had kept in the divorce settlement, which I had repainted last spring in a shade called pale wheat that my mother would have called yellow and I called honest, was quiet when I got home. I put the groceries on the counter. I stood there for a long moment, not moving. Then I sat down at the kitchen table and I let myself feel it. Fear. Real fear. The kind that sits in the chest cavity and makes ordinary breathing feel effortful. $7 million. The number moved through my mind like a slow tide. $7 million that Derek had contributed nothing toward, that my mother had built over a lifetime of careful choices, that she had structured with deliberate legal precision before Derek Mitchell existed in either of our lives. And yet here we were, a motion filed, a hearing scheduled, attorneys billing by the hour, and Derek laughing in a courthouse hallway as if the outcome were already written. I understood, sitting at that table in my too quiet house, that fear had a function. It was informational. It was telling me something true, that I was in a real fight with real stakes, and that I could not afford the luxury of assuming the law would simply protect me without my active participation. So I did what I always do when a problem exceeds my immediate comprehension. I made a list. I got out a yellow legal pad, my mother's habit, which I had inherited along with her stubbornness, and I wrote at the top, what do I actually know? What I knew, factually and without emotion, My mother had created an irrevocable spendthrift trust in 1998. I had been the sole named beneficiary since its inception. The trust had been professionally managed for over 2 decades. The $14 million I had received was not a direct bequest of cash or property. It was a distribution from a legal entity that had existed and been formally documented long before Derek Mitchell and I exchanged vows. What Derek's attorney was arguing, as Patricia had explained, was a theory of marital property timing, that because the distribution arrived during the marriage, it was subject to equitable distribution under North Carolina law. What Derek's attorney appeared not to know, or was hoping the court might overlook, was the nature of the trust instrument itself. I called Patricia at 8 o'clock that evening. She answered on the second ring, which told me she had been expecting my call. "Walk me through the trust language," I said. She did. I took notes on my yellow legal pad for 45 minutes. Patricia Owens was 61 years old, had practiced family law for 32 years, and spoke with the particular economy of someone who had sat across from a great deal of human foolishness and was no longer surprised by any of it. She used words like spendthrift provision and beneficiaries' separate property and anti-alienation clause with the calm clarity of a surgeon describing anatomy. When she finished, I put down my pen. So the trust specifically prohibits a beneficiary's creditors, or a beneficiary's spouse, from making claims against trust assets. I said, "Correct. And that language has been in place since 1998. Since 1998. And Derek's attorney filed this motion without pulling the full trust documents." There was a brief pause. "It appears," Patricia said carefully, "that opposing counsel reviewed the probate filings, saw the distribution amount, and made assumptions about the instrument structure without requesting the original trust agreement from the trustee." I looked at my legal pad. I looked at the list I had made. "That," I said, "is a significant oversight." "It is," Patricia agreed. I slept better that night than I had in weeks. Not well. Grief does not permit genuine rest, and I was still, beneath everything, a daughter in mourning. But I slept with the particular steadiness of someone who has located the ground beneath their feet. The plan, at its core, was simple. Let Derek overreach. Let him file his motions and make his arguments and stand in courthouse hallways laughing. Let him believe that money and confidence in Vanessa Cole's cream blazer constituted a legal strategy. And then let Patricia Owens put a single document on a table. But before that document could do its work, I needed to understand the full terrain of what I was facing. Over the following 2 weeks, I did 3 things. First, I gathered every piece of financial documentation related to the trust that I could access, not because Patricia lacked them, but because I needed to understand them myself. I sat at my kitchen table with a highlighter and read trust law summaries and North Carolina case precedents until I understood not just what the document said, but why they said it, why my mother had chosen this particular structure, why she had consulted an estate attorney in Raleigh in 1998 and paid for careful, detailed, far-sighted legal work. She had been protecting me. Not from Derek specifically. She couldn't have known Derek in 1998. She had been protecting me from the general category of unforeseen futures. Eleanor Hartwell had understood something about the world that I was only now, at 44 years old, fully grasping, that a woman's security should never depend entirely on the goodwill of another person. Second, I called my financial advisor and asked him to prepare a clear accounting of the trust's history, its establishment date, its management records, its valuation over time, in a format that could be presented to a court. Third, I said nothing to Derek. This last item was, in some ways, the most difficult. Derek had sent 3 text messages in the weeks following the filing, each one calibrated to a particular emotional frequency. The first was practical. "Sarah, we should talk about this. Lawyers make everything worse." The second was nostalgic. "I know things got complicated, but I don't want us to be enemies." The third, arriving on a Wednesday evening, was faintly threatening. "My attorney thinks this goes strongly in my favor. Just want you to be prepared." I read each message once. I forwarded each one to Patricia. I did not reply. Let him think whatever he wanted. Let him think my silence was confusion or fear or resignation. I had my yellow legal pad. I had Patricia Owens. And somewhere in a filing cabinet in a law office in Raleigh, I had a trust document dated 1998 that was going to end this conversation completely. Patricia filed our formal response to Derek's motion on a Tuesday morning. I was in my office at the hospital. I had returned to work full-time after the divorce, back to healthcare administration, back to the particular sanity of systems and budgets and problems that had solutions, when she called to tell me it was done. "We've also filed a request for production of documents," she said. "Derek's attorney will need to disclose all communications regarding the trust prior to filing the motion, and we've subpoenaed the original trust records directly from the trustee in Raleigh." "Good," I said. "Sarah." Patricia's voice had a texture I had come to recognize. Not alarm exactly, but heightened attention. "I want you to be aware that opposing counsel may escalate. When they realize the strength of our position, the behavior of the parties involved may become less predictable." I thought of Derek in the courthouse hallway, of that laugh. "I'll be prepared," I said. What I had not anticipated was Vanessa. I had been careful throughout the divorce and its aftermath not to invest significant emotional energy in Vanessa Cole. She was a fact of my situation, not its cause. Derek's choices had made her relevant. Those same choices were entirely his own. I did not blame her with the specific hot energy of a woman who has been wronged by another woman. I understood clearly enough that Derek had made every decision that mattered, but Vanessa was not content to remain peripheral. It started with the social media. I was not a frequent user of Instagram, but a friend, Carol Brewer, who had been my closest friend since graduate school and who had the particular loyalty of someone who shows up with food and doesn't ask unnecessary questions, texted me a screenshot on a Thursday evening. Vanessa had posted a photograph. She and Derek at what appeared to be a rooftop restaurant in Charlotte, glasses raised, the city lights soft in the background. The caption read, "Some battles are worth fighting. #new chapter, #truth." I looked at the photograph for a long time. Then I forwarded it to Patricia. "Is this relevant?" I asked. "Potentially," Patricia said. "Keep everything." I kept everything. It was Carol who first said aloud what I had begun to suspect. We were sitting in her kitchen in Myers Park on a Friday evening, wine open, the comfortable silence of long friendship between us, when she put down her glass and said, "Sarah, how did Derek even know the trust amount? You said the distribution wasn't public record in the way he'd have access to." I looked at her. She was right. The probate filing had disclosed the distribution amount. That much was public. But the trust itself, its terms, its provisions, its establishment date, those were private documents held by the trustee. Derek's attorney had filed a motion describing the inheritance in broad strokes, claiming it as marital property without ever specifying the trust's internal structure, which meant one of two things. Either Derek's attorney was proceeding on incomplete information, which was Patricia's initial assessment, or Derek himself knew more about the trust structure than he had disclosed. I drove home from Carol's that night with the radio still off and my hands quiet on the wheel, and a new question forming in the back of my mind like a weather system building on the horizon. The answer arrived 9 days later in the form of a document produced in response to our discovery request. Among the emails disclosed by Derek's attorney, filed somewhat reluctantly, Patricia noted, after a deadline extension and a terse exchange of letters, was a thread from October 2021, 6 weeks after my mother's death, 3 weeks before Derek's attorney filed the amended motion. In the thread, Derek was communicating with someone named Robert Slade, not his attorney, but a private consultant whose LinkedIn profile, which I looked up that same evening, described him as specializing in asset investigation and estate research. Derek had hired this man, independently, before filing. Robert Slade's email to Derek, dated October 14, 2021, read in part, "The trust was established in 1998 as an irrevocable spendthrift trust under North Carolina law. Standard spendthrift provisions would typically bar claims by a beneficiary's creditors or spouse. However, the specific anti-alienation language and whether the distribution constitutes transmuted marital property will be a question for the court. There is legal argument on both sides. If you proceed, you should be prepared for the trust documents to be central to the case." Derek had read this email. He had known, before filing, that the trust might be structured in a way that defeated his claim entirely. He had proceeded anyway. I read that email sitting at my kitchen table at 11 o'clock at night, the house very quiet, the yellow legal pad in front of me. My hands were steady. My breathing was even. He had known the risk. He had calculated that I might not fight hard enough, or that I wouldn't find this email, or that he could wear me down before it mattered. He had gambled on my compliance. I picked up my phone and called Patricia. "I have something," I said. "Tell me." I read her the email. There was a silence on the other end of the line, not a long one. Patricia Owens did not waste time on theatrical pauses. "Sarah," she said finally, "he walked into this knowing the trust documents could end his case. His attorney filed without subpoenaing those documents, and now we have written proof that Derek was fully briefed on the risk before he chose to proceed. Yes, this changes things significantly. I know. It speaks to bad faith, potentially frivolous litigation. We can ask for attorney's fees." I looked at my legal pad, at the notes I had been keeping for weeks, at my mother's habit of careful, thorough, patient documentation made real in my own handwriting. "Let's ask for everything we can," I said. Patricia moved efficiently. Within 48 hours of our late-night call, she had filed an amended response to Derek's motion, formally introducing the Slade email into evidence and flagging the bad faith litigation question to the court. She also sent a formal letter to opposing counsel, Derek's attorney, a man named Brian Frost, whom I had met once and found aggressively mediocre, advising him that we would be seeking attorney's fees under North Carolina statute if the motion was not voluntarily withdrawn. Brian Frost did not withdraw the motion, but something shifted in Derek's behavior within the week, and the shift was not subtle. He called me on a Wednesday evening. I was in my kitchen making dinner. Something simple, pasta, the kind of meal you make when you want the comfort of a task with a clear outcome. And my phone lit up with his name, and I stood there for a moment looking at it before I answered. "Sarah." His voice was different from the courthouse hallway. The ease was still there, the practiced smoothness, but underneath it something had tightened. "I think we need to talk, without the attorneys." "No," I said. "I'm serious. This is getting out of hand. Brian says, "Derek, I can't discuss the case with you directly. You know that. Call Patricia's office." "I'm not calling your attorney, I'm calling you. We were married for 11 years. Can we just—" "Call Patricia's office," I said, and ended the call. I stood at the stove and stirred the pasta and breathed slowly. My heart was beating faster than I would have liked. 11 years leaves traces in the nervous system whether you want it to or not. I forwarded the call log to Patricia. The following Saturday, Vanessa came to my house. I say that plainly because there is no way to say it that doesn't sound slightly surreal. I was in my front garden. Early April in Charlotte is genuinely beautiful, and I had taken up a modest interest in container gardening the previous fall, which my therapist had called healthy externalization, and which I called having something alive to look after. When a car I didn't recognize pulled up in front of the house and Vanessa Cole got out. She was dressed carefully, that cream blazer again, or one very like it. Her expression was arranged into something meant to read as conciliatory. "I know this is strange," she said, stopping at the edge of my driveway. She had enough social awareness not to walk up to my door uninvited. I just wanted to talk, woman to woman. I put down my trowel. I looked at her. "Vanessa," I said, "whatever you're about to say, I'm going to tell you the same thing I told Derek. Contact my attorney, and I'm going to ask you not to come to my home again." She held her expression for a moment, then something shifted underneath it, the careful pleasantness thinning into something harder. "You should think about what you're doing," she said. "Derek has friends in this city, people who know your hospital, your board. This doesn't have to get messy, but it can." I looked at her for a long moment. A mockingbird was calling from the magnolia tree at the corner of my yard. The April sun was warm on my shoulders. "Are you threatening me?" I asked, calmly, genuinely curious. She did not answer, but her jaw tightened. "I'm going to go inside now," I said, "and I'm going to call my attorney. If you contact me again or approach my workplace or make any representations to my employer or my professional board, Patricia will file for a restraining order and include your visit today in the documentation." I paused. "Have a good afternoon." I went inside. I locked the door. I stood in my hallway for 30 seconds with my back against the door, breathing. Then I called Patricia. She was, as always, direct. "I'll send Vanessa's attorney, if she has one, a formal cease and desist regarding contact. I'll also document the implied professional threat for the bad faith record. Sarah, this is actually useful for us." "Useful," I repeated. "They're frightened. Frightened people make mistakes." I filed the call log and the garden confrontation in the manila folder I had labeled, with my mother's methodical instinct, evidence, active. Then I did something I had been postponing for 2 months. I took 4 days off work. I drove to Asheville, my mother's city, the city of my wedding, the city where she had squeezed my hand and said the most important thing a woman can own is her own judgment. And I rented a small house near the River Arts District, and I did very little for 4 days. I walked along the French Broad River in the mornings. I ate dinner at a restaurant where no one knew me. I called Carol once and my therapist once and no one else. On the 3rd evening, sitting on the porch of the rented house with tea going cold in my hands and the Blue Ridge Mountains going dark at the horizon, I thought about my mother. I thought about her sitting in 1998 in an attorney's office in Raleigh, establishing a trust with careful, far-sighted language, protecting a daughter from futures she couldn't name. She had known. She hadn't known about Derek specifically, but she had known about the general shape of the world and the specific importance of documents. I went to bed early. I slept deeply. I woke up ready. I drove back to Charlotte on a Sunday morning with the windows down and the mountains in the rearview mirror, and something in my chest that I can only describe as settled. Not happy, precisely. Grief doesn't resolve in 4 days, and neither does the particular fatigue of sustained conflict. But settled, the way a level reads when the bubble finally centers. Patricia had emailed twice while I was gone. Both messages were procedural: deposition scheduling, a minor exchange of documents with Frost's office, a note that the court had confirmed the hearing date for May 14th, 5 weeks away. I read the emails at my kitchen table on Sunday evening with a cup of coffee and my legal pad, and felt, for the first time in months, something that resembled the normal functioning of my own mind. On Tuesday, Brian Frost, Derek's attorney, sent Patricia a letter proposing a settlement. I read it in Patricia's office on a gray Wednesday morning, the kind of Charlotte spring day that can't decide whether it's winter. Patricia sat across from me with her reading glasses on and her hands folded. The letter proposed that Sarah accept a payment from Derek of $400,000, described as recognition of marital contribution during the inheritance period, and in exchange for dropping all claims of attorney's fees and bad faith litigation, and signing a document releasing Derek from further claims related to the estate. I read it twice. "He's retreating," I said. "Partially," Patricia said. "The offer is still premised on the idea that he has some legitimate claim to a portion of the trust. It's a negotiating position. He's hoping $400,000 sounds like a win compared to $7 million. It's not a win," I said. "It's an acknowledgement that he has no case." Patricia removed her glasses and set them on the desk. "That's my read as well. I want to reject it. I recommend we do." She paused. "I also want you to think about what you want the outcome of the hearing to be. Not just the legal outcome, the personal one." I thought about that for a moment. The gray light came through the office windows. Somewhere in the building, a phone rang and was answered. "I want the court to see the trust document," I said. "I want it on the record. I want Brian Frost to have to stand in front of a judge and explain why he filed a motion without pulling the founding instrument of the trust he was challenging." Patricia's expression did not change, but something in her eyes sharpened, the way a good attorney's eyes sharpen when they hear the answer they were hoping to hear. "Then that is what we'll do," she said. We rejected the settlement offer that afternoon. Derek's response arrived the following morning in the form of a text message to my personal phone, which I had not yet blocked because Patricia had advised me to continue documenting contact. "Sarah, this is getting ridiculous. I don't want to be at war with you. We had a life together. Your mother liked me. Just take the money and let's both move on." I read it twice, as I had read the settlement letter. I noted with clinical detachment the rhetorical technique, the appeal to shared history, the invocation of my mother who had died in September and who, as a matter of documented fact, had specifically structured her estate in a way that excluded Derek Mitchell from accessing a single dollar of it. My mother had liked Derek in the way one sometimes likes a plausible surface. She had trusted her own judgment more than her goodwill toward him. I forwarded the text to Patricia. I did not reply. That evening, Carol came over with Thai food and wine, and the comfortable certainty of a friend who knows when to talk and when not to. We sat on my back porch while the evening came in over the Charlotte neighborhood, and I told her about the settlement offer, and she said very simply, "You're going to win this." "Patricia says the trust language is clear," I said. "I'm not talking about Patricia," Carol said. "I'm talking about you." I had also, in the weeks since Asheville, begun attending a monthly meeting of a professional women's group, not a legal support group, not a divorce support group, simply a gathering of women in healthcare and finance and law who met at a wine bar in Dilworth on the first Tuesday of each month to talk about work and life and the particular negotiations involved in being a woman who takes up appropriate space in the world. My therapist had mentioned it months ago. I had finally called the organizer. The first meeting I attended, I didn't say much about my situation. The second, I mentioned the lawsuit in broad terms. 3 women at the table, a CFO, a corporate attorney, and a cardiologist, looked at me with the specific recognition of women who have been in adjacent rooms to similar fights. "He filed without pulling the trust documents," the corporate attorney said. "He did." She picked up her wine. "Then this is already over," she said. "He just doesn't know it yet." I drove home from that meeting feeling something I hadn't felt in months. Not relief, not triumph. Something quieter and more durable. Solidarity. The knowledge that the ground I was standing on was not only legal, but human. 5 weeks until the hearing. The bubble was centered. I was ready. 2 weeks before the hearing, I attended the birthday dinner of a woman named Diane Kowalski, a hospital board member and one of those warm, efficient people who holds an institution together through sheer force of goodwill. I had debated not going. The timing felt precarious. My attention was elsewhere. But Carol said, "You cannot let this lawsuit shrink your life," and she was right. So I put on a blue dress and drove to the restaurant in South End and told myself the evening would be ordinary. It was ordinary for approximately 40 minutes. I was standing near the bar talking to Diane's husband about a renovation project, genuinely focused, genuinely present, when I felt the particular awareness of someone watching me from across a room. I turned. Derek and Vanessa were there. Later, I would confirm that Diane had not known about the lawsuit. She had invited Derek as a professional acquaintance from a community development committee they'd both served on, months ago, before any of this began. There was no conspiracy in the invitation. The world is sometimes simply poorly timed. But Derek had known I would be there. I was certain of it in the moment I met his eyes across Diane Kowalski's birthday dinner, and the certainty was confirmed by the speed with which he moved toward me. Vanessa, a half step behind, both of them wearing the carefully constructed expressions of people who have rehearsed an approach. "Sarah," Derek said. His voice had the softness of a man performing generosity in public. "I'm really glad you're here. I've been hoping we'd have a chance to just talk, without all the legal machinery." I held my drink and looked at him. The restaurant was warm, the other guests largely oblivious to us, Diane laughing at something near the window. "Derek," I said, "you know I can't discuss pending litigation." "It doesn't have to be litigation," he said. He lowered his voice in the way people do when they want to seem reasonable. "Sarah, listen. This is hurting both of us. I have Vanessa's income to think about now, a whole new phase of life starting. I'm not trying to take what's yours. I just think that 11 years meant something, and a small recognition of that." "You've already filed a motion for $7 million, I said. "That isn't a small recognition." His expression shifted. Not dramatically. Derek had always been too controlled for dramatic shifts, but something recalibrated behind his eyes. Vanessa stepped forward. "Sarah," she said, and her voice had none of the careful conciliation she'd attempted in my driveway. This was something more direct. "I want you to understand what the next 2 weeks are going to look like for you if this goes to the hearing. Derek has talked to people. Your professional network in this city is not as solid as you think." I looked at her. The restaurant noise continued around us. Diane laughed again near the window. "Are you telling me he intends to damage my professional reputation?" I said. clearly, audibly enough that Vanessa glanced sideways at the nearest cluster of guests. "I'm saying," she said, lowering her voice, "that things can get complicated in ways that don't need to happen. Derek is offering to settle for $300,000 now. That's less than his last offer. He's trying to be fair. After May 14th, he won't be in a position to make that offer anymore." She let that hang in the air. "Think about what you actually want." What I actually wanted. I stood in Diane Kowalski's birthday restaurant in my blue dress, holding a glass of sparkling water, and I thought about what I actually wanted. I wanted the court to see the document dated 1998. I wanted Brian Frost to explain himself to a judge. I wanted the bad faith litigation filing to be on the public record. And I wanted, with a quiet clarity that surprised even me, for this conversation to be over. "I'm going to walk away now," I said. Not loudly, not with any performance of it. "If you approach me again tonight, I'll ask Diane to address it, and I'll document this conversation for my attorney in detail tomorrow morning." I turned and walked to the other side of the room. My hands were completely steady. My face was, I believed, composed. But in my chest, something sharp was moving. Not panic, but its near neighbor. The clarity of real threat. Because Vanessa had not been entirely bluffing. Derek did have contacts in Charlotte's professional community, and a whisper campaign, however unfounded, could create friction. Friction meant distraction. Distraction meant weakness. I said goodnight to Diane at 9 o'clock, thanked her genuinely, and drove home. I sat at my kitchen table with my legal pad and wrote down every word of the conversation from the restaurant. Every word. Time, location, witnesses in proximity, exact phrasing of the professional threat. Then I called Patricia and left a voicemail, calm and precise, laying it out. Then I sat with the fear for a while. Let it be there. Carol had once told me that the goal wasn't the absence of fear, but the presence of something stronger, and I had thought that was a greeting card sentiment at the time. But sitting at my kitchen table at 10 o'clock the night of Diane's birthday dinner, I understood that she was right. The fear was real. The resolution it produced was more real. 13 days until May 14th. May 14th arrived as a gray Tuesday, the kind of morning that offers no particular comfort or drama. Low clouds over Charlotte, the drive to the Mecklenburg County Courthouse quiet, my coffee in a travel mug, Patricia beside me in the elevator, both of us saying very little. Courtroom 4B was smaller than the cinematic version of a courtroom that the word courtroom conjures. Fluorescent lighting, institutional carpeting, the smell of paper and central air. Derek was already there when we entered, seated at the respondents' table with Brian Frost, who was shuffling documents with the focused energy of a man who needed to appear busier than he was. Vanessa was in the gallery, third row, the cream blazer again. Derek looked at me when I walked in. I looked at him. Neither of us nodded. Judge Helen Thornton entered at 9:02, and the bailiff called the room to order, and the case of Mitchell versus Hartwell Mitchell was called, and the hearing began. Brian Frost argued first. He was smoother than I had expected. I had underestimated him, which Patricia had warned me not to do, and she was right. He presented the timing argument cleanly. The trust distribution had arrived during the calendar year of the marriage, had been deposited into accounts that were technically accessible to both parties, and under equitable distribution principles, the court should consider it marital property. He cited 3 cases. He used the word fairness 4 times. He did not cite the founding trust document. He cited the distribution record. Judge Thornton listened without expression. She was 62 years old with reading glasses on a cord around her neck and the particular composure of someone who has heard every variety of human financial argument and is moved by none of them. Then Patricia rose. She began quietly, "Your Honor, the question before this court is straightforward, and the answer is contained in a single document that opposing counsel did not request in discovery and is not cited in his motion." She placed the trust agreement on the table. The original certified copy from the trustee's office in Raleigh, 47 pages dated September 14, 1998. "This is the Eleanor Hartwell Irrevocable Spendthrift Trust," Patricia said, "established 23 years ago, 13 years before the petitioner married the respondent, with the respondent named as sole beneficiary from its inception." She walked Judge Thornton through the relevant clauses methodically. The anti-alienation provision, which explicitly stated that trust assets could not be subject to claims by any creditor or spouse of the beneficiary. The spendthrift clause, protecting the beneficiary's interest from third-party claims. The establishment date, predating the marriage by more than a decade. Brian Frost was very still. The distribution received by respondent in October 2021, Patricia continued, was not a cash bequest subject to equitable distribution. It was a distribution from an irrevocable trust that has existed as a separate legal entity since 1998. The trust's assets have never been marital property. They cannot become marital property by the act of distribution. Opposing counsel's motion rests on a fundamental mischaracterization of the instrument structure. Judge Thornton looked at Brian Frost over her reading glasses. "Counselor, did you review the founding trust document before filing?" There was a pause that lasted approximately 4 seconds. In a courtroom, 4 seconds of attorney silence is a geological event. "We reviewed the probate distribution records, Your Honor," Frost said. "That's not what I asked." Another pause. "We did not have the founding document in our possession at the time of filing." The judge's expression did not change. She made a note. Patricia then introduced the Slade email. She read the relevant passage aloud. The specific anti-alienation language and whether the distribution constitutes transmuted marital property will be a question for the court, and noted that this document, produced in discovery, demonstrated that the petitioner had been advised of the trust's potential spendthrift structure prior to filing his motion. Petitioner proceeded with the motion despite being informed that the trust instrument might categorically defeat his claim, Patricia said. "We are therefore requesting, under North Carolina General Statute 6-21.5, an award of attorney's fees on grounds of frivolous and bad faith litigation." Derek turned to say something to Frost in a low voice. Frost put a hand on his arm, the universal attorney gesture for stop talking. Judge Thornton looked at the Slade email. She looked at the trust document. She looked at Brian Frost. "Counselor," she said, "would you like time to confer with your client before responding to the attorney's fees request?" Frost said they would appreciate a 15-minute recess. In the corridor outside courtroom 4B, I stood with Patricia near a window that looked out over the parking structure. The low clouds had broken slightly. A thin line of pale sun was visible at the horizon. "He knew," I said. "Yes," Patricia said, "and now so does the judge." Through the closed courtroom door, I heard, or imagined I heard, the sound of Derek's voice, rapid and low, the particular cadence of a man explaining himself, of a man who had walked into a fight having already read the document that would end it, having gambled that the document would stay hidden, that I would settle, that I would be less than I am. Vanessa was in the gallery behind that door in her cream blazer, watching. I thought about my mother in 1998 in an attorney's office in Raleigh signing 47 pages. I thought about own your own judgment. Patricia and I walked back into the courtroom when the bailiff called. I sat down, folded my hands, and waited. Brian Frost, after his 15-minute conference with Derek, returned to the courtroom and attempted one more argument. I will give him credit for trying. He argued transmutation, the theory that even protected trust assets can become marital property if the beneficiary treats them as joint assets, commingles them with marital funds, uses them for joint purposes, or otherwise acts in a way that signals intent to convert them. Patricia stood, and with the measured efficiency of someone who had not wasted a single hour of her 32 years of practice, introduced 3 exhibits. The first, the trust's banking records, showing that the distribution had been received into an individual account opened in Sarah Hartwell's name only after the separation date, never jointly accessed. The second, the separation agreement signed by both parties in February 2021, 8 months before the distribution arrived, in which Derek had formally acknowledged that Sarah's separate property interests were her sole concern. The third, a declaration from the trustee himself, confirming that no distribution had been made during the marriage and that the account had been managed exclusively as a trust asset until October 2021. There is no evidence of transmutation, Patricia said. The funds were never commingled. The separation had legally occurred. The distribution arrived into a separate account. The transmutation doctrine has no application to these facts. Judge Thornton had stopped writing. She was looking at Frost with the expression of someone waiting politely for a conclusion to an argument that is already concluded. "Does the petitioner have anything further?" she said. Frost looked at his papers. He looked at Derek. Derek was staring at the table. "No, Your Honor," Frost said. Judge Thornton removed her reading glasses. "The petitioner's motion for equitable distribution of trust assets is denied," she said. "The court finds that the Eleanor Hartwell Irrevocable Spendthrift Trust, established in 1998, constitutes separate property not subject to equitable distribution under North Carolina law. The distribution received by the respondent in October 2021 was a distribution from a pre-existing separate property trust, not a marital asset." She paused. "The court further finds that the petitioner's motion was filed in the absence of due diligence regarding the trust's founding instrument, and that documentary evidence produced in discovery indicates the petitioner was aware of the trust's potential spendthrift structure prior to filing. The court awards attorney's fees to the respondent pursuant to North Carolina General Statute 6-21.5. It was over. Patricia placed her hand briefly on my forearm. Not dramatically, just the small, steady pressure of a professional who knows when something real has happened. Then she began gathering documents with her usual efficiency. Across the room, Derek stood up slowly. He looked for a moment at nothing in particular, the fixed stare of a man who has walked into a wall that should not have been there. Then he looked at me. I met his eyes. I didn't look away, and I didn't perform anything. No coldness, no triumph, no relish. I was simply there, in the ordinary fluorescent light of courtroom 4B. He turned and walked out. Vanessa left the gallery without speaking to anyone. The cream blazer disappeared through the door, and I thought simply and without malice, she tied herself to a losing bet. The attorney's fees, when submitted, came to $47,000. The judge awarded $41,500, Not the full amount, but enough. Enough to be on the record, enough to say, this litigation was frivolous. I received a formal letter confirming that no appeal would be filed. No appeal. I stood at my kitchen table reading that letter on a Thursday evening in June, the windows open, the Charlotte summer beginning its long, warm campaign. I had not cried through any of it, not in the courthouse, not driving home. I cried that evening in my kitchen, quietly, for about 10 minutes, not for Derek, not even for the money or the fight, for my mother, for the 47 pages she had signed in 1998, for the fact that her care had outlived her. The most important thing a woman can own is her own judgment. Yes, Mom, and the trust agreement that protects it. By October, I had repainted my home office in a color called soft mineral blue and done it myself on a Saturday with the windows open and a playlist my mother would have called too loud. I stood in the finished room with paint on my hands and thought, this is what returning to yourself feels like. Work steadied. Carol and I had dinner every other week. I began seeing someone named Daniel, a structural engineer, calm and genuine, and we took it slowly, which was exactly what I wanted. What I heard about Derek, I heard through ordinary channels. His firm lost 2 more contracts. Brian Frost's handling of our case attracted a state bar complaint. Vanessa was no longer appearing on her agency's website by spring. I felt no triumph, only the quiet recognition of cause-producing effect, decisions followed by consequences, with the patient logic of water finding its level. By the following May, I was standing in my garden, which had grown considerably. Daniel was inside making breakfast. The mockingbird was back in the magnolia. My house was my house. My name was my name. The morning was warm and ordinary and mine. It was 47 pages of careful, patient, far-sighted documentation, created by a woman who loved me enough to plan for futures she couldn't see. I learned that silence can be a strategy, that fear, properly directed, becomes fuel, that a laugh in a courthouse hallway is just noise when you have the right document. So I want to ask you, if you were standing in that parking lot, hearing that number, looking at that motion, what would you have done? If this story made you think, made you feel, or made you reach for the phone to check your own paperwork, I understand completely. Leave a comment. Tell me what you would have done. Thank you for listening.